the learned judge says, in the course of argument, the presiding judge put to counsel the following list of the elements that should guide a court in making a decision. And then follow the 7 points which we've listed in our heads, and which include, amongst other things, whether the last bullet point is whether class action is most appropriate. And the third bullet point is the question of whether the right to relief depends upon the determination of issues of fact or law or both common to all members. And His Lordship, having recited those 7 points, goes on to say that there's an overlapping in these requirements, and he explains that. And in his explanation in the last sentence of paragraph 26, he says, and I quote, "A class action may be certified in respect of limited issues, for example, negligence in a mass personal injuries claim, leaving issues personal to the members of the class, such as damages, to be resolved separately." And we emphasize that because what it does is that it simply, on a practical and convenient level, when it addresses the question of commonality, it merely requires that there be some issues of fact or law which are common to all members. Not that all issues of fact or all issues of law are common to all members, simply a degree of commonality in those issues, which in the views of the court addressing the question of certification warrant a class action. And there are many ways that the pie can be cut up. If there are particularized issues of individual damages, then those may or may not be dealt with in the class action. They can quite easily be dealt with separately. It may be helpful just to give your Lordship a quick précis. I'm sure your Lordship's read the case, but to refresh your memory. McAdam's case, like the Children's Resource Centre case, concerned certification that was sought in respect of a class action arising from what was price fixing amongst bread producers. And the McAdam case dealt with a class action that distributors of bread, who was supplied by the manufacturers who were accused of price fixing, and who distributed to members of the public. What was sought by the distributors under the McAdam case was certification of a class action in which the individual damages suffered by each of the distributors were to be claimed. And that was one of the objections to the class action, that the damages were personal to each. And one of the factors that was considered both in the SCA and the Concord was whether in fact there was any cause of action for those sort of damages in the ordinary course. Ultimately, the Constitutional Court decided that there was some scope, albeit poorly pleaded and articulated, there was some scope for thinking that there may be a case to be made for damages suffered by the distributors, but damages in the particularized sense of damages referred to and adumbrated in Section 22 of the Competition Act. And that was really the essence of the decision of the case. But even McAdam's case didn't say that there has to be commonality of all issues. And McAdam's case didn't say that even where one has individual and particularized heads of damage, i.e. that one would have to show that each member suffered a particular quantum of damage, that that was a basis for non-suiting a class action. And to put this in context, if I could invite your Lordship to go to paragraph 44 of Wallace J.A.'s judgment in the Children's Resource case. It's at page 105 of the bundle. Dealing with the question of commonality under the heading of common issues of fact or law, His Lordship makes the starting observation, which quite frankly is destructive of the respondent's argument. He says this commonality does not require that every claim advanced in the class action, save possibly in relation to quantum, be identical. It requires that there be issues of fact or law, or both fact and law, that are common to all members of the class and can appropriately be determined in one action. Dealing with the issue of commonality in Walmark, Scalia J said that was in the United States jurisprudence, that this must depend on a common intention. The common contention, moreover, must be of such a nature that it must be capable of class-wide resolution, which means that determination of its truth or falsity will resolve an issue of fact that is central to the validity of each one of the claims in one stroke. And if I can stop there for a moment, in this case, unlike perhaps a case which could arise in a different contractual setting, where it comes to the merits of this particular case, the question simply is, has there been a contravention of the particular provisions of the Consumer Protection Act which have been put forward? That's an objective question, and it's a question which a court will answer with regard to what the respondents did and said in their websites, in their application forms, and what they did or didn't bury in a link which contained different conditions. So that, whether there was a misrepresentation or improper conduct, is an objective inquiry, and it's central to all of the potential claims, and it concerns only what the respondents said and did and published. And that is germane to all of the relief claim. If the answer to that is the respondent's conduct offends the Consumer Protection Act, or the respondent's conduct amounted to fraudulent misrepresentations, that then is the basis, and the basis per se, of the declaratory relief and the interdictory relief. That meets even the American test, and it does so because, as Wallace J.A. said, it doesn't require that every claim be identical. There may be different components of the claim, but what there must be is at least one issue of law or fact. Whether they're assuming there are 20 issues of law or fact and only one is common, that may be a factor which the court takes into account, and saying, well, there's only one common factor, that doesn't really make, doesn't weigh up in the overall inquiry, either as to commonality or appropriateness to sustain a class action. But that, with great respect, is not how we understand the respondent's argument. The respondent's argument seems to be that these are absolute requirements in the form of jurisdictional facts. And His Lordship goes on to explain that in paragraph 45. And again, at the risk of being tendentious, I quote, that having explained in paragraph 44 the simple issue of a simple example of a common issue, in 45 His Lordship says that highlights the point that the class action does not have to dispose of every aspect of the claim in order to obtain certification. It might, in an appropriate case, be restricted to the primary issue of liability, leaving quantum to be dealt with by individual claimants. Certainly, common issues could be certified for the entire class, and other subsidiary issues certified in respect of defined subclasses. The question in respect of any class or subclass is always whether there are common issues that can be determined that would dispose of all or a significant part of the claims by the members of the class or subclass. And it was for that reason that somewhat tediously I went through the various categories of relief which are claimed. All of those categories of relief pertain to all members of the class as it is sought to be defined. There's not one leg of that relief which doesn't pertain to the class as it is sought to be defined. And then in paragraph 46, Wallace J.A. went on to point to the distinction on which our learned friends for the respondents place some reliance between the Canadian approach and the American approach and the Australian approach. And he says, in the United States, it's an express requirement that the representative plaintiff has a claim that is typical of the claims of the class. Now, if I can stop there for a moment, in American jurisprudence, the representative plaintiff must have a claim. So, in a representative action such as this, one of the plaintiffs, for example, the Law Society, would have to have a claim, for example, for restitution of debit orders or payments made under the contract. In Canada, His Lordship, in Australia, His Lordship says there's no express requirement of typicality. He goes on to deal with Professor Mulheron's suggestion. And then, and this is the important part, the question does not arise in South Africa because Section 38C of the Constitution expressly contemplates a class action being pursued by, and quote, anyone acting as a member of or in the interests of a class. There are other categories as well, but what that means is that unlike the United States and even to a lesser extent Canada and Australia, you have to have a representative plaintiff in respect to the claims. In our law, we don't, because the Constitution and equally Section 4.1 of the Consumer Protection Act envisage that actions of this nature can be brought by plaintiffs such as, frankly, PRASA, LegalWise, and the Stellenbosch Law Clinic, who do not have claims but are merely acting in the public interest. So it's for that reason that we say the respondents have completely misconceived the import of these dicta, and that error on their part has been compounded by the complete failure to have any regard to what Justice Jafta said in the McAdam case. And if I may invite your Lordship to go in the joint bundle of authorities to page 239. And in that, the Constitutional Court, I must check, I was in that case, but as far as I recall, Justice Jafta spoke for the full court in saying, and I quote, in Children's Resource Centre, the Supreme Court of Appeal laid down requirements for certification. These requirements,
what paragraph?
35, my Lord.
Thank you.
In Children's Resource Centre, the SCA laid down requirements for certification. And this is the important part. These requirements must serve as factors to be taken into account in determining where the interests of justice lie. That makes it clear that these are merely considerations, that the ultimate criterion is the interests of justice. And His Lordship goes on. They must not be treated as conditions precedent or jurisdictional facts which must be present before an application for certification may succeed, which is exactly what the respondents seek to do. He goes on. The absence of one or other requirement must not oblige a court to refuse certification where the interests of justice demand otherwise. The implication of that is that even in a case such as the present, you've got a respondent which has conceded all the requirements for certification of the 7 except 2, commonality and appropriateness. Even if the respondent were correct in that, and for the reasons which I'll explain they're not, but even if they were correct on the approach which the Constitutional Court has adopted, exemplified in paragraph 35 of Justice Jafta's judgment, that does not warrant the refusal of certification, even if the respondents were correct. It would at best for them merely be a factor to be taken into account. The question then is, to what extent is their complaint regarding commonality and appropriateness justified? And if it's justified at all, what weight will the court afford that in weighing up the interests of justice? And our submission is, firstly, that factually the complaints about commonality and appropriateness are completely misdirected and have no root in the facts of this case. Here we know exactly what the respondents are alleged to have done. It's there. We can see the websites. We know what the alleged contraventions are. The contraventions are common to every member of the class. And the only question is, are there differential components which are not common to all the members? And frankly, there aren't. One can go through whether it's the interdictory relief, the declaratory relief, or in fact what we've called the damages or the restitutionary relief. It runs like a common thread. All of them are subject to the same principles and commonality. The second aspect then is appropriateness. Now, we are dealing here, and this isn't disputed, we are dealing here with a class of persons which comprises people who are financially distressed, who are plainly not sophisticated to the wiles of contractual terms buried in links elsewhere, and who are easily misled. We can say that with a great deal of confidence because there are not only the affidavits from the 2nd to 9th applicants, and your Lordship can see exactly the facts articulated by them which gave rise to these proceedings, and which I might add are not only not gainsaid but can't be gainsaid. But your Lordship knows as well that the Law Clinic has been deluged with thousands of people in similar positions. There are Facebook platforms where this is a perennial problem raised by hundreds of people. Your Lordship knows from PRASA that it has been a problem, that one of the factors that PRASA took into account, takes into account, as my learned friend Mr. Price explained, is where you have a disproportionate number of debit orders which are contested as opposed to those which are allowed. How do all of these people vindicate their rights under the Consumer Protection Act and the general rights of the public to the protections enjoyed by that act? There is, with great respect, no other effective way to do it. And the contrived attempts by the respondents to conjure up other mechanisms achieves exactly the opposite. It demonstrates that there is no other viable alternative. And if I could ask your lordship to consider them. The first is the advertising standards. Now, we know that complaints were made initially against one of the company under another name, which was apparently part of Mr. Melander's same group. Complaints were upheld, but, and that was way back in 2015, where are we now? We are sitting, certainly in 2019 and 2020, with the same kind of complaints of misleading advertising, misleading websites, and so on. So going to the Advertising Standards Authority at best achieves some sort of temporary and casuistic result of a particular advertisement. It doesn't either remedy the consequences of that, setting aside of the agreements, restitutionary orders, declaratives that the agreements are void, nor does it prevent future misconduct in the sense that the interdicts
can't interdict going forward.
Yes. And the same applies. I mean, the real lesson of...
Sorry, there's a bad echo. Nor can it grant any form of compensation or damages.
Yes. And the other lesson that emerges from the Advertising Standards Authority is it doesn't correct the behavior. It's the respondents sail on regardless in due course. They might change a word here or there, obey an injunction temporarily, but very soon it's business as usual. The same applies to the the CDC, the credit control body. Again, adverse findings have not resulted in preventing the kind of conduct that we complain of here. The other inspired thought is that all of these people, and on the respondent's own version, there are at least some 31,000 potential members of the class, must go off to the small claims court. Now, one can just imagine people who are financially...
I don't think you even need to go there. The suggestion is utterly preposterous. To clog up the small claims court with 1,000 claimants here and 1,000 claimants there will be so invasive of other people's abilities to vindicate their rights that it really is not an option.
As your lordship pleases. So
there's a more fundamental basis, isn't there? Can you litigate CPA rights in the small claims court?
I must be honest, my lord, it's something that hadn't occurred to me. I don't think you can, but I'd like to check that. I don't want to be opportunistic and agree. I think it is probably correct, but if I may, I'd like to check and perhaps...
Yeah,
so where are we on the certification? The learned friend for the respondents accepts that of what he seems to, or the respondents seem to regard as the 7 criteria, all are met except for 2. And even those 2, we say, are the complaints that they are not met are specious and contrived. So that brings us to the point where we submit on the conspectus of all of these facts, and bearing in mind that the objective of a class action ultimately is to serve the interests of justice, bearing in mind that the Consumer Protection Act strives to achieve a particular form of fair regulation in an environment, and that the conduct that is being complained of here is an offence not only to any basic understanding of business propriety and ethics, but to a whole plethora of specific provisions in the Consumer Protection Act. We submit that the interests of justice can only be served by way of a class action. If your Lordship is with us on the interim interdict and the certification, then we submit it would follow that the costs of these proceedings and of both legs should be borne by the respondents, and by that I mean all the respondents except the 19th respondent, and we would ask that those costs include the costs of two counsel.
So you're asking for the costs of two counsel, and you expressly exclude the 19th respondent from any cost liability.
Yes. We are hoping to deliver, unfortunately logistics are a bit retarded because of distances, but I understand that there is an affidavit in the course of attestation by my instructing attorney which will confirm that the 19th respondent did not file answering affidavits, and on the basis that the understanding would be that costs would not be sought against her, and that she is aware of these proceedings today and has been aware of the conduct of the matter.
Well, you're not asking for relief against her at all, are you?
Well, she is one of the defendants in the class action. To that extent, there is relief against her, but at this juncture, other than to the extent that certification involves an action against her, there's no substantive relief.
Yeah, I follow.
And my learned friend, Mr. Kelly, who's far faster on his feet than I am, has just reminded me that the aspect which your Lordship raised is actually dealt with in our heads of argument, and your Lordship's point was quite correct. Our heads of argument, paragraphs 154 and 155, deal with the small claims court aspect. That's at page 75 of the paginated heads of argument. And section 16 in brackets G specifically excludes any relief, interdictory relief from the jurisdiction of the small claims court.
Mr. Dickerson, is the question of potential prescription a factor for consideration generally, and in this matter in particular, because you're asking for relief that kicks off in 2015, I think it is.
Yes.
And the application was served in, was it September, October 2019?
There could, I don't think these are points that have been taken now, but the prescriptive aspect has two components. The first question is whether there may be a defense of prescription tenable on the action as it is sought to be certified. It may be, but that is something that would have to be pleaded, and there may be answers to it on the basis that parties didn't know their rights or couldn't reasonably have known certain things. There may be other questions about whether prescription can be raised in the face of the contents of the Consumer Protection Act. But that is all of that would be encompassed in whether there's a defence or not, which we submitted would be pleaded out. But your Lordship's point raises another aspect, and that is, apart from defences that may lie to the action which is envisaged, there can be no doubt that prescription, to the extent that it can run, would be ticking but for this application.
Yeah.
So whatever claims may or may not have prescribed, a bar comes down when the application for certification is made in September of 2019, and that bar acts as a protection, if I can call it that, for the claimants in the class action, unless, of course, certification is refused, in which case there would be no interruption of prescription until some other form of action or class action is instituted. The point really being that we are now the better part of 18 months down the line from the launching of this application, and during that 18 months, if certification is refused, there is the potential that there may have been a number of claims which prescribe to the extent that prescription runs. And I don't want to
No, sorry, my question comes from a slightly different angle. So certification is granted, and on the face of it, simply by looking at the dates involved, there is the potential for prescription to be raised as a defence in respect of everybody before September 2016.
Yes.
Anybody who subscribed to this website before September 2016 might or might not be hit by a prescription. How do the respondents defend themselves against that in a class action?
Well, they plead it in the same way that anybody else would. They plead that whatever claims arose, and I can only imagine it would apply to monetary claims.
Yeah.
They would plead that debits or payments that were made before a certain date prescribed, and the issue would then be, well, A, are these the kind of claims which are susceptible to prescription, bearing in mind the provisions of the Consumer Protection Act? In other words, can prescription overcome illegality? It may be that it can, but the court seized of the class action would decide that.
Yeah, well, I presume they would know from their records who concluded a contract when, so that they could put up a list of 10 or 20 or 100 people and say, these people fall foul of the prescription, fall foul of the commencement date, which would be September 2016, and their claims are therefore prescribed.
Yes.
And there would be no prejudice to them by certifying in such circumstances, because no. they would be able to clearly identify such claims as they may wish to allege have prescribed.
Yes.
Yeah.
I think, and it's perhaps a point that I should have made, but haven't. In common, well, it's in common with the Bread case, which was both the Children's Resource Centre and McAdam's case, most of the information that is required for this class action, both by the plaintiffs and the defendants, if not all of that information, is in the respondents' possession. The respondents are the only ones who know exactly how many agreements they concluded. They're the only ones who know who they concluded agreements with. They're the only ones who know what amounts were debited to the accounts of those customers, for want of a better word, and they're the only ones who know what reimbursements, if any, were made. we say on the papers it's clear that there weren't. But so discovery in this, as with many class actions by the respondents, is going to be an important exercise, and there's nothing really in relation to any of these claims which isn't already in the possession of the respondents. It may be that in due course extracting that information and extracting the documents from the respondents is a difficult task, but that's the problem that plaintiffs face in class actions. But the point of all of that is it's very difficult to conceive how the respondents could be prejudiced in any way. There's not a single aspect of the factual underpinnings of the claim which is not within their domain and to which they don't have access. And the only way that one can get to it, which comes back, I suppose, in an indirect way to the question of appropriateness, is by way of a class action where one can have discovery, enforced discovery by the respondents of everything.
Yeah.
Because it's only by getting discovery from the respondents that one can get to the truth of this systemic course of what we submit as fraudulent and unlawful conduct. To try and do that through one or two isolated individual claims by clients simply cannot achieve the overall result. I hope I've addressed your lordship.
Yes, thank you. I mean, it's not seriously raised by the respondents anyway as a basis for not certifying.
But unless there are particular aspects on which your lordship.
No, thank you, Mr. Dickinson. I think you've covered everything that I need to know and that you need to hear, and if necessary, I'll hear you in reply.
As the court pleases.
Ms. Mayosi, I now have a full set of the papers in the joinder application. Should we do that now? I see it's 10 to 3. So we've got an hour or so left. Should we do that at this stage? Does it suit you now?
We can do that at this stage, my lord.
Thank you very much. And thank you to Kluwer and Makoto, who got this one down so smartly. Stellenbosch well represented here, I can see.
Yes, I must thank my colleague Luke Kelly for getting the papers to you, my lord.
Thank you. Now, let me just go back to my notes to see what where your points terminated. Yes, you take off wherever it's you, Ms. Mayosi.
Yes, as the court pleases, my lord. My lord, there cannot have been any doubt in the mind of the respondents opposing the intervention application as to exactly what relief, what capacity legal-wise sought to be in the certification application, which is the main application. This matter was in fact dealt with by the respondent, my lord. I wish to refer you first to the respondent's answering affidavit, which is the affidavit of Mr. Malander, on page 100 and in the intervention application, my lord. Page 180. Where from paragraphs 25 to 28, the respondents sought to address precisely why it is, in their view, LegalWise is not a suitable party to be certified. So it was clear on the papers as filed that the question of being certified as a representative of a class in the certification action, in the certification main application, was in fact an issue on these papers. In reply, the applicant, LegalWise, then placed the matter beyond any doubt, because of course the applicant then dealt with this issue even fairly more squarely and succinctly. And if I may refer, my lord, and those are the papers you didn't have earlier, to record page 209, which is the replying affidavit of deposed to by Ms. Anna Sophia Anderhay on behalf of LegalWise.
Paragraph number?
Paragraph number 13, and I'll refer you to various places where this matter was placed beyond any doubt. Starting with paragraph number 13, where in the second sentence of that paragraph, LegalWise says that it's ideally suited to assist their members in this regard and will add a significant value as an additional class representative alongside the first to ninth applicants in the certification application. On the following page, my lord, paragraph 15, once again, LegalWise makes it clear that it seeks to intervene in its own interest as well as a class representative in the interest of the class. Page 212, my lord. On paragraph 23, once again, the second sentence of that paragraph, LegalWise's members form part of the putative class and should the certification application succeed, this doesn't preclude LegalWise from intervening and adding value as a further class representatives. It continues on the following page, on page 213, my lord. And even more clearly on paragraph 24 of page 213, second sentence, it's denied that LegalWise does not seek to be appointed as a class representative, and it goes on and goes on in this affidavit.
Sorry, let me understand you. Let me understand you clearly. So LegalWise wants to be admitted to join the university, the law clinic, as a representative, as a class representative.
Correct, my lord. And the assertion you would have heard made this morning was an objection from the respondents based on the fact, as they said it, this was the first they were hearing of that today, and they would object to the intervention if it was pursued on that basis. The point I'm simply seeking to make, my lord, now is this, but they've always known that this is the intervention is sought on this basis. It was clearly stated on the papers. And this affidavit is dated the 13th of March, 2020. We are 5 days shy of a year from when this replying affidavit was filed by LegalWise. In correspondence that Mr. Dickerson alluded to, engagements that he alluded to earlier this morning, which are not before this court, my lord, when the parties were just discussing the general conduct of this matter, one of the invitations that was made by LegalWise to the attorneys of record of the respondents was to say, let's agree to an order in terms of which you can file whatever affidavits you seek to file to address issues that are in LegalWise's papers that you didn't address in your answering affidavits. The response came back and the response said, no, rather let's hear these applications separately, and so on and so on. So we are now down the road almost a year after this replying affidavit was filed, and we hear now today that there's an objection to LegalWise representing the class because this has never been heard before. Quite apart from it having been dealt with on the papers, my lord, it was also dealt with by LegalWise in its heads of argument, my lord, that were filed last year. And if I can just, the heads of argument are dated 25 of March 2020. And if I could just refer, my lord, to the various paragraphs in the heads of argument of LegalWise.
Please. I've got your heads. Yes, I do. Page
Yes,
113 of the.
Yes, they're dated. Our heads are dated the 25th of March 2020, and there, at paragraph 45 of those heads, it's clear that LegalWise also proposes in this application to intervene and act as a co-representative together with the Law Clinic, which the Law Clinic supports. Once again, that is made throughout the rest of paragraph 45 onto the next page. Those assertions are repeated once again in the heads of argument on paragraph 46, and once again in paragraph 51 of LegalWise's heads of argument. How do the respondents then respond in they answering their own heads of argument? And this is where we ended earlier this morning, my lord, when I was attempting to address you. And if I may refer you, my lord, then to page 7 of the heads of argument filed by the respondent, where from
of the respondent's heads in
the intervention.
LegalWise application.
Correct, my lord.
Paragraph 7.
Page 7, paragraphs 20 to 24.
Oh, yes.
Yes. There, the respondents deal with why they say LegalWise is not suitable to be certified. Fully aware, my lord, that this is one of the things that LegalWise seeks in this intervention application. And there, in those paragraphs, from paragraph 20 up to paragraph 24, they object to the suitability of LegalWise on the basis of some alleged conflict of interest that LegalWise may have. And that is stated in paragraph 22. I will address that later, my lord. There's no merit to that assertion. So the first objection attacking the suitability of LegalWise to be certified is LegalWise is seeking to create some conflict of interest, and that is what is said in paragraph 22. And then again in paragraph 23 of the heads of argument, it is said that LegalWise is also unsuitable to be certified because it is, for some reason, it will not be able to be impartial in relation to those members who wish to opt out of the class. I'll address that later, my lord. Once again, I contend that there's no merit to those attacks. But the point I wish to make, my lord, for us today now, almost a year later, for the respondents to be raising these new issues, these new objections that were not raised before, and to seek to file an affidavit when they failed to do so, there's no merit, my lord, to that, and it can only have the effect of delaying these proceedings.
I have the submission.
As the court pleases. My lord, I now deal with why we say that LegalWise has a direct and substantial interest in the subject matter of the certification application, and why it is that.
Could you deal with that in a little more detail, because I'd like to understand exactly what it is that LegalWise, to use the vernacular, brings to the party.
As the court pleases, my lord. My lord, as will have been alluded to or submitted by Mr. Dickerson in his earlier arguments, we submit, first of all, that based on Section 38 of the Constitution and Section 4 of the CPA, LegalWise has standing to bring the intervention application. LegalWise has standing in the certification application. Now, what LegalWise has put before this court in its founding affidavit is conduct reported to it by its clients, its members, that it provides legal insured services to, of conduct.
Well, could I just understand from you, does LegalWise provide the same sort of service which the respondents allege that, or which the respondents allege that they were set up to provide?
LegalWise doesn't accept that it is a competitor of the respondents, my lord. It rejects this outright in the papers. LegalWise joins calls with the applicants in the.
I know they say that they're scamsters. I understand that they're scam artists. But do they operate in the same field as which the respondents say they were set up to operate? Not that they did operate, but the respondents say, you signed up with us for a legal services package, and we provided it to umpteen people. All I'm asking is that if that allegation is correct, does it mean that LegalWise and the respondents operate in the same commercial area? You put it that level.
My lord, if that allegation is correct, in order for it to be correct and to in fact have a legal effect, it would have to be established that the respondents can lawfully provide such a service. It was indeed stated earlier by Mr. Dickerson that they're in no position, you will not find it anywhere in the papers that they have the requisite authorities by the LPC to provide the services that they say they provide. So that's the first fundamental problem with any kind of comparison or admission that we are all operating in the same space, because it can never be that what they do can be equated to what LegalWise is doing lawfully in terms of the Short-Term Insurance Act and the services that it provides lawfully under that umbrella. So Lord, what LegalWise has then done, it comes to court and it says, we've received complaints from since 2 years ago, and these complaints from our members mirror in quite material aspects the complaints that are raised by the 2nd to 9th applicants and the plethora of similar complaints received by Stellenbosch University in relation to the operations of the respondents. The LegalWise then comes to court. LegalWise provides, to the extent that it can, the evidence that shows where letters of demand have been issued to its members in circumstances where they say they are being scammed, in circumstances where they say they are being held liable for services that, 1, they never received, or 2, they never signed up for. And in that regard, my lord, if I may refer you to the annexures, SUAS U4 on page 140 of the record.
Of your record?
Yes, the intervention record, my lord. So from page 140, 142, 43, 144, your lordship will see clients or members of LegalWise writing to LegalWise counselors and saying, I need your help. I'm being scammed. This is not genuine. Your lordship will see a letter of demand on page 144, which was sent to LegalWise by one of its members, a Mr. Simpiwe Kwabe. Your lordship will see on page 157 of the record, which is where Mr. Romeo Everts shows that he has in fact been blacklisted by Lifestyle.
Just a moment, please. Which page is that?
Page 157, my lord. And there are confirmatory affidavits from this gentleman later on in the record showing, just confirming that this is what happened to them. So it's clear, my lord, that there's an entire group of people.
Sorry, this is a LegalWise client who was blacklisted by one of the respondents' companies.
Yes, my lord. It's a Mr. Romeo Everett, I think it is.
Yeah.
So there is a...
Explain to me, to the extent that LegalWise has clients of its own who have insurance, who have legal insurance with it, who have been fleeced by, allegedly fleeced by the respondent, how does that give LegalWise then an interest to seek to be involved? Because if I'm understanding your argument correctly, LegalWise is saying, look, we can provide proof which will back up the applicant's claims from a number of our clients.
Yes.
Does it need to be part of the class action to do that? Could it not simply cooperate rather, with the applicants and say, you know, you can subpoena us and we will bring the documentation along, and we will give you the names and addresses of people who can be subpoenaed as well.
Yes.
Why does it need to be joined as a representative party?
So what legal
to the court's attention? Sorry.
So the submissions in that regard, my lord, is that LegalWise has direct, and this of course goes to the suitability of LegalWise in particular to be certified. And one of these aspects talks to the fact that it is able to access the evidence that relates to the members who were scammed, who say that they were scammed. It will be able to assist in the management of the litigation, because it has direct access to the evidence that is required in the ultimate class action, and which it has put some of that before this court. 1, 2.
Just a moment, please. Sorry, just a moment, please. What number of LegalWise clients are there that it can show with least? Are we talking about tens, hundreds, or thousands?
So at the time of deposing to the papers, my lord, in 2019, the deponent at the time was aware of 80 complaints that had made their way to, yes, 80 at the time. I don't know how many. It's very possible that there may have been more by now, because quite a bit of time has passed. But at the time, what your lordship will see on the papers is there was a reference to 80 known complaints at the time that the papers were deposed to.
Thank you.
And what LegalWise, of course, says is another factor that contributes also to its suitability is it contributes its expertise, its resources, and its access to geographically dispersed locations and businesses in the country in terms of managing the proposed class action. That can only promote the efficiency of the management of the class and the class action, my lord, we submit. And that is, in fact, a material factor that renders LegalWise eminently suitable to participate as a class representative in this matter. Of course, my lord, as you will know, one of the aims of class actions as a type of litigation is to promote access to justice and to facilitate judicial economy. And the fact that LegalWise will be able to assist in the management of the class in that way will, in fact, can only promote the litigation that subsequently occurs. What will also be the case, my lord, as we know that the certification of the class is sought on an opt-out basis in this in this particular matter. What the respondents say creates a conflict for LegalWise, in which we say is completely unfounded and untenable, my lord. They say, should LegalWise's members opt out, there will be some kind of conflict if LegalWise's members opt out and LegalWise is intervenes and it is appointed as a representative of the class, there might be some kind of conflict there. There's no basis for that, my lord. If members of LegalWise opt out, then of course LegalWise will perform its duty in relation to those members in accordance with the benefits that accrue in the insurance policies with it. If they wish to pursue various litigations by themselves, having opt out of benefiting from the class, it's totally untenable for the suggestion that LegalWise is contriving the creation of some kind of conflict. There is no conflict if LegalWise is appointed as a representative, my lord, to its ability to represent the class and its ability to carry on with those of its members that opt out.
But
their suggestion...
in that instance, it's in no different position to the law clinic, because the law clinic has its potential, let's say 100,000 clients. 50% of them decide to opt out, and it continues to represent the remaining 50%.
Correct, without there having been a conflict created, my lord.
It doesn't create a conflict in respect of the other 50% who decide to follow not to do anything, or to follow a different form of litigation, or seek a different form of redress.
That's correct, my lord. I agree that it's an untenable and unsubstantiated proposition made in the answering affidavit.
Does still tell me in these papers what it is? And I presume it's an insurance. It provides legal insurance, doesn't it?
Yes, it does do some. The services that are provided by LegalWise, I just want to refer your lordship to where in the record. It's a range of paralegal services, my lord. If I can refer you to record page 14, where LegalWise then describes in broad terms what services its insured members are able to enjoy.
Yes, I've seen the adverts on TV, so I get some idea of what it involves, and they are presumably one would think linked to some or other large insurance company, are they not?
Correct, my lord, and they do all of that in terms of the, I think, short-term insurance Act of 1998. That's right, my lord.
So is LegalWise here purporting to service its own clients at the same time, to the extent that there are, excuse me, to the extent that there are clients of theirs who've been fleeced, who would otherwise join in the class action through the university, through the law clinic. Does it, as part of its contractual responsibility to those clients, say, well, don't worry, I'm looking after you in the class action anyway? Or so is that more just more of a marketing exercise?
In relation to those clients who do decide to participate in the class action, my lord, I think LegalWise would perform a role which is the same as the law clinic. But what we say, my lord, is that insofar as we're talking about members of LegalWise who form part of the class, the interests of those members in the class action will be much more optimally served by the presence of LegalWise.
I understand it.
Correct. So what it will be doing, the capacity in which it will be in the class action LegalWise is very similar to the capacity played by the university, save that of course it has a broader infrastructure. It has access to the evidence required that relates to its members. And what it says on the papers is of course, it will be able to use its expertise and its resources nationwide, not only for the benefit of its members that form part of the class, but in general, towards the better management of the class action. So, my lord. So, my lord, there's no conflict of interest. I think I've intimated that there is no conflict of interests between LegalWise's ability to represent the class and the interests of its members. It, of course, has the capacity to represent the class, and it has stated so in the replying affidavit. And it has further stated that it has the capacity to participate in the class action and has the time, the means, and the inclination to procure evidence that is relevant to its members in the class action. In those circumstances, my lord, I submit that the dictum of the SA riding case, which is referred to on page 21 of my heads of argument, is apposite in relation to the intervention of LegalWise in the main application. And that dictum, my lord, is referred to on on page 21 of my heads of argument in the intervention.
So what page are you? What page of the bundle, of the combined bundle of heads, or is yours not paginated? Your microphone's off, Ms. Mears.
Apologies, my lord.
Yeah,
I'm just
so
looking.
you were referring me to the SA riding case in your heads.
Yes, correct, my lord. And
now,
that's
which paragraph of your heads?
paragraph 47 of my heads, my lord. And the submission made there, my lord, is that a proper case has been made out for the intervention of LegalWise on the basis and the principles set out in paragraph 10 of the SA riding case. And that case is in the combined authorities bundle at page 153, my lord. And your lordship will see, in addition to the dictum set out in paragraph 10 of SA riding, in paragraph 11 of SA riding, it referred with approval to the Grevenau case that formulated the principle that an applicant who bases their claim for intervention on direct and substantial interest in the subject matter of the dispute, a court has now discretion and must allow them to intervene, because that matter should not proceed in the absence of parties having such legally recognized interest. My lord, I submit that this is such a case. And that LegalWise's interest in the main application is indeed substantial and direct, and any order or judgment made by the court in that matter will indeed affect the interests of its members.
Yes, carry on.
Lord, unless there's something else directly you want me to address, I persist with the submissions as set out in the heads of argument.
Yeah, I'm just looking at the categorization of direct and substantial. So it has a direct interest because its clients have been fleeced or have allegedly been fleeced by this operation, and it can assist the university in running its case because it can provide direct evidence to support the university's case.
Correct, my lord.
To the extent that the university says these people who are your clients are also our clients or our plaintiffs, it can then bolster the case for those plaintiffs by bringing direct evidence from its own records.
Correct, my lord. And of course, if it is participating in the class action, LegalWise itself will be better able to protect the interests of its members in the context of the class. There are concepts like opting in and opting out and so on that LegalWise would need to ensure that its members understand, because if members, for example, do not opt out, they may find themselves bound by any do not opt out for some reason, perhaps because they didn't know, or that has serious consequences on its members. So it will be able to provide better protection to the rights of its members in the context of the management and the issues that arise in that class, for those who are in the class. But of course, for those who are outside of the class, who opt out and who wish to pursue matters differently, that can still occur.
Yeah. Yes, thank you, Ms. Mayosi. I think you've covered everything that I need to hear. Thank you for your assistance.
And
thank you for getting your camera straight this time.
Thank you, my lord. You were very unhappy last time.
Mr. Botma, it's nearly 3:30. Are you happy to start now? Do you want to spend half an hour this afternoon, or would you rather kick off first thing tomorrow morning?
Lord, what I propose is, I see that your Lordship invited my learned friend to just point your Lordship to the main authorities and the legal principles in applications such as these. I noted that he went over that very briefly, and I'd like to accept that invitation of your Lordship. And perhaps before we break for today, just highlight the current state of the law as I understand it, and perhaps that would set the stage for the submissions that I intend to make tomorrow morning.
Yes, with pleasure.
My Lord, a very useful highbrow analysis or summary of the history of these applications is found in a chapter of a book that, incidentally, Mr. Kelly was one of the editors of. It's the Class Action in South Africa book, and it's in your Lordship's bundle, and it appears at page 175. The chapter that's copied in there is chapter 2. The book is divided in a whole section of chapters, and it's got guest authors in most of them. This chapter was authored by Mr. Unterhalter SC, as he then was. He has since, as your Lordship know, taken up a position at the bench, and he's also written one of the key judgments that I will place reliance on tomorrow, Mr. Unterhalter and Mr. Kustudis. I think Mr. Kustudis is also a member of the bar. That chapter deals with certification and specifically with the history of these applications and why certifications are important, and then what are the factors that are taken into account. And Mr. Dickerson is quite correct that whilst these factors are referred to often as requirements, the Constitutional Court in Macadam, I stand corrected, I also thought it was Mukadam, did say that one has to take a more holistic approach. Now, in chapter 2, the authors then discuss all of these requirements, and the two requirements that we will highlight, the ones of commonality and appropriateness, what your Lordship will find at page 179. commonality, that the right of relief depends upon determination of an issue of fact, both common to all members of the class. And the authors in that paragraph...
What's the date of this edition, Mr. Portman?
Beg your pardon, my lord, I missed that.
What's the date of this? The date of this book, of this edition?
Publication. I've got the book right in front of me, my lord. The date, it was published in 2017, my lord.
Thank you.
And
is it loose leaf or is it?
No, my lord. It's a
regulation text.
It's a regulation textbook.
Right. Thank you.
So the commonality aspect is dealt with in at page 179, and the two most important cases in the commonality is the case of...
Are you saying commonality or commonality?
Commonality, but I can understand why your lordship in the context of this case may have made that mistake. So the commonality aspect is dealt with at page 179. The two most important cases that's referenced in this section of the book is the Children's Resources Centre judgment. That's the seminal judgment in these type of matters. And then the Gauteng Johannesburg Division of the High Court delivered a full bench judgment in a matter in Nkala that had a different, more lenient approach to the SEA's approach in children's resources. Interestingly, Nkala was determined after children's resources, and the authors also opine about what the impact of Nkala should be, in as far as it's inconsistent with the SEA's previous judgment.
Just a moment. So, Nkala, what is the date of Nkala? Sorry, let me get the dates right here. Children's Resource Centre was what date?
My lord, the Children's Resource Centre is 2013. It's a 2013 judgment.
No, it's reported in 2013. When was the judgment given?
Oh, yes, that's correct, my lord. It was reported in 2013. Let's just get the judgment in front of me. It was heard on the 7th of November 2012, my lord.
And judgment delivered?
On the 29th of November 2012.
Right. And in Nkala's judgment, it was the full bench, was it not?
It was the full bench, my lord.
In which Justice Unterhalter, or acting judge of appeal Unterhalter, he was part of that bench.
No, my lord, he wasn't. The bench was Deputy Judge President Mojapelo, Valle, and Windle. And the judgment was authored... Sorry.
Yeah. And Nkala is dated when?
The judgment was heard on the 12th to the 23rd of October 2015. And the judgment was delivered on the 13th of May in 2016.
Was Nkala one of the mining ones?
Yes.
Silicosis.
Correct.
Yes, carry on. So you're suggesting that Nkala contemplates a slightly less onerous test than what was contemplated by the SCA?
Correct, Lord. Correct. When it comes to the issues of commonality, and Nkala also conflated the issue of commonality and appropriateness, because it said that if there is sufficient commonality amongst a large enough class, then class actions would be appropriate. And that aspect is then discussed in this chapter.
Mr. Botman, on the basis that the SCA sets the test, and 3 or 4 years later, a local division comes along and fixes the test differently, to what extent can I have any regard to the local divisions, even though it's full bench, where there's SCA authority?
That is my point, my lord. The test that I advocate for is the test in Children's Resources Centre. Your Lordship, the Nkala judgment is not contained in the joint bundle of authorities. However, if your Lordship would like to have regard to it, prior to the joint bundle being compiled, I sent up a bundle to your lordship of the cases that
Yeah,
I believe were relevant.
Yeah.
And the Nkala judgment is at page 62 of that bundle. So
Yes.
as far as your lordship would like to have regard to that case. The issue of class actions, my lord, has really its genesis in the Constitution, in Section 38 of the Constitution. Section 38 of the Constitution suggests that any person can come to court to vindicate someone else's rights under the Bill of Rights. And for some time it was suggested that NGOs and other non-governmental institutions or people who would like to do so can come to court to vindicate rights, and that is my understanding how often organizations such as Freedom Under Law and a whole lot of other organizations have come to court to protect rights in the Bill of Rights. Children's Resource Centre represented a significant departure from that. And Children's Resource Centre being heard on the 7th of November of 2012, interestingly, McAdam's case, which your lordship will find at page 232 of the combined bundle, was heard the day before. So that case was heard on the 6th of November 2012 by the SCA, and it was the same judges who heard McAdam, heard Children's Resources. It was a bench of Nugent, Ponnen, Milan, Heki, and Wallace. And Mr. Dickerson appeared in both of these applications.
So which case was heard first? Mukadam
so from the record, it appears that McAdam was heard on the 6th of November.
And the other one?
And the other one was heard the following day on the 7th of November, my lord.
You say the same bench involved?
Correct, my lord. And the judgment was delivered on the same day in both cases, on the 29th of November. Justice Wallace delivered the judgment in Children's Resources Centre, and Justice Nugent delivered the judgment in McAdam's case.
Yeah.
And when one reads the judgments, it is clear that one should read Children's Resources first, because McAdam's case, Justice Nugent refers to that judgment and just adds to it in the particular circumstances of the McAdam case before it. Now, the McAdam case was then escalated to the Constitutional Court, where the judgment of the SCA was reversed. And your lordship will find the Constitutional Court judgment at page 236 of the combined bundle.
Yep, I have you.
So what one sees from Children's Resources is that subsequent to the dawn of democracy, there was moves afoot by several law commissions to introduce class action lawsuits into South African common law. Previously, that was something foreign to our law. And the difficulty with that is that a representative's decisions, be it a settlement decision or a decision to abandon a judgment, that would bind members of a class, of a putative class, and significantly, the court can make orders that may be adverse to parties who are not before it, parties who are represented before it. So it represented quite a significant departure from the joinder rules and the rules of Audi and what we've come to be accustomed with in how we deal with matters. The court in Children's Resources dealt with the particular facts of McAdam and Children's Resources were, very briefly, your lordship will recall a couple of years ago, the Competition Commission got wind of bread producers in the Western Cape that fixed the price of bread. And they fixed the price of bread not only in the Western Cape, but nationally. And one of, I think it was Pioneer, took advantage of the whistleblower legislations or provisions in the Competition Act and regulations to blow a lid off the entire thing. And everybody then had eventually been investigated by the Competition Commission, and massive fines were paid, some in the region of 90 million and 120 million rand. Subsequent to that, Mr. McAdam and the Children's Resources Centre approached the Western Cape Division of the High Court. I see the judge who heard the matter in the first instance was an acting Judge van Zyl. I don't know whether that's Francois van Zyl or whether that would have been Susan van Zyl, but it was an acting Judge van Zyl in 2013 who refused the certification application.
Yeah, I think it was HF van Zyl SC.
There we go. Might be. The matter was then escalated to the Supreme Court of Appeal. It was heard as an urgent application in this division, and the judges in the Judge Wallace is quite sympathetic to the acting judge who dismissed the application, because we'll see it's quite an intricate part of our law, and Justice Wallace had the benefit of competent and thorough submissions by various senior counsels on this matter. It was Wim Trengrove, Skalkberger, Mr. Dickerson, and Unterhalter. So it's a heavy hitting team. And the SCA lamented the fact that Parliament has sat on its hands in implementing legislation to regulate class actions, and then took the opportunity to create a mechanism through which this should be regulated. It adjudicated firstly whether certification is required. Now, across the common law world, one has to first get certification and then institute your action, except for in Australia. In Australia, you can just kick off with a class action, and then it's up to the respondents to bring something akin to an exception that the matter should be decertified, so to speak. The conclusion was reached that within the framework of South Africa that shouldn't work, and there was some debate about whether Section 38 of the Constitution limited class action proceedings to matters contained in the Bill of Rights. And ultimately, the SCA held that it didn't, that one can bring these type of applications in any matter, and that the particular realities of South Africa warrants that the common law be developed in that direction, because we have
was that the
a lot of
in CRC?
Correct, Lord. Yeah, on the Children's Resource Centre. And Justice Wallace then proceeds to delineate the 7 factors that are then adjudicated or expounded upon in Chapter 2 of that book that I referred to. And I'm not going to spend my time going through all of them, but the important aspect is that the court then borrows the idea from, when it comes to commonality, from Justice Scalia in the USA. And whatever one may think of Justice Scalia's personal politics, he was, in my submission, a great legal mind, nevertheless. And he raised the point that when it came to commonality, and that's at page 105, Justice Wallace deals with commonality of the bundle.
Just a moment. 105 of the bundle.
Correct.
Yeah.
So your Lordship will see at paragraph 44, Justice Wallace borrows from the USA, and there's a case of Walmart where Justice Scalia said that when it comes to commonality, the claims must depend upon a common contention, that common contention, moreover, must be of such a nature that it must be capable of class-wide resolution, which means that determination of its truth or falsity will resolve an issue that is central to the validity of each one of the claims in one stroke. Now, that's what's been referred to by Mr. Dickerson quite correctly as the American approach. In the synopsis on commonality in Mr. Kelly's book, the American approach is contrasted with a Canadian approach, and the Canadian approach has a lot lower threshold for establishing commonality. And essentially, it's not essential in the Canadian approach that class members be identically situated vis-a-vis the respondents. And all that is required is that there must be some substantial ingredient that moves the litigation forward. Now, that's as far as commonality is then concerned. In children's resources...
Sorry, just a moment. So what you excuse me, what you're saying over here is that in CRC, the SCA opts for the American approach.
Yes, my lord, that is exactly what I'm saying.
Because Wallace J.A. says, in my view, that is correct, immediately after the quote.
Correct, my lord. So that is the standard.
So who has advanced the Canadian approach? Only the authors?
No, my lord. Then Nkala appears to advance the Canadian approach.
I follow.
And in Nkala, the approach was a lot more lenient, and our submission is that was incorrect. In another important aspect that Justice Wallace highlighted in CRC was that applicant for certification should provide a draft particulars of claim in his certification application. And the reason for that is so that
that's been sorted out here, hasn't it?
Yes, it has.
It's a supplementary affidavit, and it's attached, and the argument, I think, has been addressed.
Yes, it has. In the context of this case, but to explain what happened in this matter, it's important to briefly touch on that.
On
what happened in CRC. So what happened in CRC is the court then had that prerequisite, said it was peremptory, and the reason for that is so that the court can look at what the cause of action is, and it can weigh this cause of action and see whether there's prima facie evidence, and that would be the first requirement. In the CRC, the court resolved and came to the conclusion that there might be a case for the CRC to make, but that the court de quo didn't have the benefit of that case being set out eloquently or correctly or sufficiently, and then referred the matter back to that court, to this division. And I haven't found a...
I recall, now that you've reminded me, when the CRC matter, that was the first bread case that came before the courts, wasn't it?
Yes, my lord.
And it was Advocate H.F. Francois Fonsal, who was acting. And the thing came before in third division, and I think he dealt with it in the fast track. I happen to remember being around at the time. I think he dealt with it in the fast track or an overflow from the fast track the following week. The matter was dealt with speedily.
Very speedily.
And it was dealt with with a minimum of fuss, let me put it that way.
Correct. And what comes out of this judgment is that one of the reasons why it was dealt with quite summarily was there was a debate about whether prescription would ensue, but the SCA ultimately then also held that the mere commencement of the certification application is sufficient to interrupt prescription. So the matter was then sent back to this division. I'm not entirely sure what happened to the matter. It seems to have died a quiet death. The Cadams case, in contrast, which was on the same fact.
Sorry. It was sent back by the SCA. It was sent back to do what?
The order to get further evidence, it would appear. The order appears at page 111 of the bundle. So the applicants were granted leave to supplement their papers by delivering the supplementary affidavits that are annexed to a set particulars of claim, embodying the further evidence as they may deem meet in amplification of that claim. So it was really to provide them an opportunity, a second bite at the cherry, now that this framework had been established, because everybody was walking around in the dark up until that point. So the SCA held that there's prospects of a claim that may be in CRC's hands, and sent it back for them to be provided with an opportunity to augment their case. McAdam's case was heard in the previous day, and the judgment by the SCA was given on the same day by Justice Nugent. And he endorsed also in that judgment the framework set out in CRC. However, in that case, the SCA arrived at a conclusion that Mr. McAdam was unable to show a cause of action, and that no amount of supplementary affidavits would cure that deficiency. And his appeal was accordingly dismissed.
Yes, carry on.
The dismissal of that appeal was taken on appeal to the Constitutional Court. That's the McAdam Constitutional Court matter. And in that matter, the Constitutional Court held that the SCA erred in dismissing his appeal, that he should be afforded the same opportunity as the Resource Centre, and that his appeal should also be referred back to the Court of First Instance. And it was then in that judgment where the SCA made the point that the requirements set out in CRC shouldn't be read as a checklist, but rather should be viewed as a set of factors that assist the court in arriving at a conclusion as to whether certification would be in the interest of justice. Their matter stood for some time, and this application was commenced. And after this application was commenced, the judgment in Steinhoff was delivered by Justice Unterhalter. And your Lordship will find the Steinhoff judgment at page 113 of this bundle. That matter was heard on the 20th to the 24th of April last year, 2020. And the judgment was dated 26 June 2020.
Yes.
Now, personally, I found this judgment extremely useful. It's a difficult judgment to read because the facts are quite intricate. But quite briefly, what happened in this matter was a pensioner. They say that she, in the head note, in the summary, it says that she invested 80 million rand. That's not correct. She invested 80,000 rand. But a pensioner brought an application for certification of a class action against the directors of Steinhoff, and then also Deloitte, their auditors, as well as Steinhoff Holdings and the Steinhoff company in Frankfurt. And it's once again
the German companies joined in the class action.
Beg your pardon, my lord?
The German companies joined in the class action.
Yes, that's how I understand it. They are identifiable by the suffix NV.
Yeah. As well as a number of important local businessmen I see in the list of parties.
Yes, including Mr. Jooster. So the central premise in this case was that Ms. De Bruyn suggested that she relied on a certain prospectus that the directors gave out about the financial wealth of Steinhoff, and also the financial statements that Steinhoff published in order to inform her decision to invest her pension money in Stellenbosch shares. That information appeared to be false. There's an allegation that the directors were negligent, but there's also an allegation that Mr. Jooste had dolus, in other words, that he intended to mislead. And on the basis of that misrepresentation, she entered into an agreement to purchase shares, and she obviously lost a lot of money when the whole matter came tumbling down. And she intended to bring a class action on behalf of all persons who held Stellenbosch shares and lost money. Now, your lordship will also see that the classes are subdivided in certain subclasses. I don't know what the reason for that is, but it may be, for example, in this case, that if one certifies the matter, you may want to certify a subclass of those individuals who held shares prior to 2016. Because their prescription aspects may be different from other class members. So one had these different types of classes that also brought different claims against different respondents.
Was that because of the nature of their shareholding?
I'm not entirely sure. It appears so, but it is a difficult judgment to read. What the judgment does do, and it's a lengthy judgment, ultimately the certification is refused. The certification is refused on the basis that Justice Unterhalter arrives at the conclusion that shareholders did not have an independent claim against the directors or Deloitte for misrepresentations that were made or any frauds that were perpetrated against the company. He arrived at the conclusion that the correct party to bring such a claim would be the Stellenbosch companies itself, because there was no fiduciary duty owed by the directors to shareholders or members of the general public. Be that as it may, I'm sure this judgment will give rise to certain debate, but he significantly finds in favor of Mr. Bruin on each of the other factors for certification, but nevertheless refuses certification, notwithstanding McAdam's Constitutional Court judgment, because he says that if you don't have a prima facie cause of action, and in that case, he made the following point. He says, in determining whether you've got a prima facie cause of action, you've got to do two things. One, you've got to ask yourself whether in law there is a case. And if there is, if you're satisfied with that, then you ask yourself whether there's prima facie evidence to support that. And in this instance, he held that in law, the case was bad, it was poorly pleaded, and it was open to exception. And he said that that was such a significant difficulty that ultimately certification had to be refused. But for our context, the judgment is also very indicative and important for matters such as whether a representative is a suitable representative. And your lordship will find the judgment of the discussion of suitability under page 119. And what is important there is Justice Unterhalter says that one has to also look at how the litigation would be financed. In this matter, the litigation was to be financed by a third party who would then presumably take a stake of the winnings, if you like. It was one of those litigation finance third-party schemes that have sprung up across the globe, and this was also an international player. And in that matter, the court then said, if it were going to certify Mr. Bruin, it would have also appointed a supervising attorney, because the difficulty is that where financial interests are at play, you often have a position where the representative or its funder's own interests aren't necessarily aligned with those of class members and class members that don't belong to it. So I highlight this because I'll return to this when we discuss LegalWise and whether I believe LegalWise is a suitable candidate to be certified tomorrow.
Well, I think if you just keep an eye on the clock, Mr.
Yes.
Botma, when it's convenient, are you going to deal with Judge Unterhalter's judgment in some more detail?
No, my lord, I'm going to point out two aspects that I believe are relevant, and then I'm going to close for the day.
All right, yeah. If you could just finish off then on that case, and we can start up tomorrow.
The other aspect of
119 paragraph 46 and following is suitability.
Correct, my lord. Then the aspect that I highlighted about how a triable issue, your lordship will find at page 127, at paragraph 120 and onwards. That's a long section.
We're not debating that in this matter.
No, we're not debating it. So one can page past that. What is very important, however, is the discussion about commonality. Your lordship will find that at page 143. And Justice Unterhalter suggests a mechanism to reconcile CRC and Nkala. And it arrives, and your lordship will find that at page 258 and onwards. I'm not going to repeat it now. We'll discuss it tomorrow.
Thank you.
And significantly, my lord, there's an aspect of an individualized defense that's discussed in this section as well that we will rely on tomorrow. And then the aspect of appropriateness, your lordship will find at page 147 and onwards, from paragraph 286. And the important factor that I wish to highlight under the appropriateness appears at page 148, and it's paragraph 293. But we'll discuss those aspects tomorrow. So that is the judicial history, if one likes, of this very novel approach to our procedural law. My submission tomorrow morning will essentially be that one has to look at this case in a normative level. I'm not going to defend my client's business practices. My submission is that when one looks at the case that is made out in the particulars of claim, whether they're declaratory or damages, that is not a case that one can certify, primarily because of commonality and appropriateness problems that are significant enough to avoid certification. And that's where we're hanging our hat, my lord.
Very well, thank you very much, Mr. Bortma. Everybody happy to start at 10 tomorrow morning? Other counsel?
Yes, my lord.
Yes.
Yes, my lord. Yes.
Mr. Price and Ms. Mayosi, you've had your says, you've had your respective says, and the court will be happy to excuse you if you wish to, but there may be something that Mr. Bortma has to say, something nasty that he has to say about you, which you might wish to deal with in reply. So it's your choice as to whether you stay on tomorrow or not. I'll leave it in your hands. But thank you. We'll adjourn until. Beg your pardon?
Thank you, my lord.
Thank you, my lord.
I'll probably stay on in case there's a need for comment or two in reply.
Very well.
Yeah.
Then we'll adjourn. Thank you, counsel, until 10 o'clock tomorrow morning.
As the court pleases.
As the court pleases.
Court pleases.